And 41156, the order to show cause to Andrew W. Shalaby.
Good morning, Your Honor. Dennis Davis appearing on behalf of the trustee.
Mr. Davis.
Good morning, Your Honor.
Chapter 7 trustee.
Mr. Mansell.
Good morning, Your Honor. Andrew Shalaby and Mr. Nakuda is with me.
Mr. Shalaby. Nakuda.
Your Honor, in preparation for responding to the order to show cause, I went back and I reviewed the documents, and I reviewed the objections, and in particular, the first item on the court's order to show cause, document number 165, deals with my objection filed on document number 146 to the trustee's objection to the exemptions of the debtor. The court is concerned, and indicates that it's concerned because I said that the objection was untimely, and the court said that I persisted with that point of view. The problem is when I went back and looked at it again, I still reached the same conclusion on it. There were three objections. There was document number 61. There was document number 94. There was document number 118. If the court looks at those three documents and compares the items on those documents to the items listed on document number 124-1, page 1 and page 2, on what the trustee later called a motion for turnover, which is actually a status conference, the court will find that I'm correct. There's no $2,741. There's no $3.11 item. There's no $211 fidelity item on there. But more important is this issue of untimeliness as it pertains to the status conference that was later heard as a motion. One of the items that the court has deferred until the appeal is remanded is $3,719 in the Bank of America account 1720. The court indicated, although it hasn't issued a ruling on it, it indicated that if the appeal is unsuccessful, the court's going to impose a $100 contempt sanction from the date of remand, I think, going forward if it's not turned over. One of the issues we presented on October 1st was that there was some double accounting and that money had been turned over twice. Another issue which we didn't present to the court, but which was presented on document number 101, which was the amendment filed on June 12th, was that there was a partnership interest to those funds. The two or three of those entities, I think two of those were partnership owned. The partners are not debtors. They have an interest in those funds. They have an interest in the $3,719. May I interrupt the court? Can I get a glass of water somewhere?
If you need to take, I don't have any here, but if you need to go and take a break, we can recess until 11:30. All right?
Thank you, Your Honor. So back to the issue of untimeliness. That I was discussing the $3,719 in bank account number 1720. The matter was presented with that dollar amount on one of the amendments, and the objection that related to it was document number 61. Document number 61 was addressing that amendment as presented, and then Mr. Nakuda later brought to my attention that he recalled that that needed to be designated as part partnership funds and part his funds. There was a subsequent amendment. There was a subsequent objection, document number 94. So I looked at document number 61, I looked at document number 94 and number 118 to determine whether in fact his objections were timely under Federal Rule of Bankruptcy Procedure Section 4003B, and whether they met the requirements of subsection C as well. And the problem is I'm still reaching the same conclusion. So on document number 61, the objection states, debtor claims an exemption in the amount of $3,719 consisting of bank account deposits, and he's addressing that issue based on that amount. Then we come back to an amendment, and that's document number 94, and he doesn't discuss it at all. And it's been changed. And it's been changed with a final version allocating not $3,719 to the debtor, but I think $1,900 and some change The court will find that on document number 101, filed on June 12th, about page 6, I think. On document number 118, which targets that amendment, keeping in mind that amendment is a complete replacement of all earlier amendments and reflects the most accurate and up-to-date information, there's nothing. It says nothing about it. What it does say on it, though, is that debtor has increased the amount of his exemption from $7,350 to $8,930.56, and he's referring to it as portion of this bank account proceeds. He's saying it's portion of a bank account proceeds. There are no monies in the bank account. These monies don't exist in the bank account. They never did. There was a check turned over to the trustee in June for $17,861. It was turned over in the form of a personal check. There's nothing on the objection that refers to that. So if the court is going to issue a sanction, the court is basically saying, don't do it again. You're wrong for doing this. Don't do it in this case. Don't do it in future cases. Well, but what if it's not wrong? What if it's right? And what if I need to do that in future cases because it's the proper thing to do under the law? That's my concern on that. Now, as far as the partnership interests, the trustee has a duty to investigate. I think it's under 11 U.S.C. section 704A2. He had this information, and he actually deposed Mr. Nakuda about it. But he didn't investigate it. He didn't say anything about it. So the proposal now is if the appeal is unsuccessful, money is going to be turned over to the trustee, part of which belongs to non-debtors. I'm concerned about that. The other concern I have pertains with tools of the trades.
We're going to stop at the first point, dealing with the accounts receivable wages, which is itemized in the court's OSC at docket number 161.1, which counsel, the court, among the unsupported positions advanced in connection with the hearing were the following. First, outlined, counsel argued that the trustee's objection to debtors' claims of exemption in, quote, the accounts receivable / wages, close quote, and, quote, bank accounts, close quote, was not timely. Similarly, counsel argued that because the objections to exemptions were not timely, the exemptions were final, and there was nothing to turn over. In making these arguments, counsel erroneously relied on the date that the trustee set these matters for hearing and conveniently ignored the fact that the trustee had filed his objections to the various exemptions well within the 30-day period following each amendment to Schedule C. The court has ruled on this. There was no motion to reconsider it brought in a timely manner, and there was no appeal. The order is final, and I've asked you to address that. Now, having said that, Mr. Davis, do you want to address the points that counsel has raised?
I honestly couldn't follow what he was saying. We filed timely objections. I couldn't tell what he was talking about.
The court is of the same mindset. The court's not following the arguments you're making, Mr. Shalaby.
I understand the court says it ruled on it. Is there an actual order to that? I don't know of it.
Mr. Shalaby?
I know the court announced its ruling on October 1, and I heard the audio, and I saw document number 154. That's the only order I saw. As to the $17,861, which I'd like to address with the court, I understand that the court said on October 1, the court announced its ruling on October 1 on the audio. It did announce it. It just, I didn't see it on a written document, is what I'm saying. I'd like to address that issue in particular, Your Honor, because...
So, I'm not sure if I understand what your argument is. Are you saying that the order this court made... All right, I'm going to just take a recess for a few minutes. I'll be right back.
Okay.
Shalaby. I went back into chambers and I printed out the order from the October 1st hearing that was signed October 2nd, 2014, docket number 152. It's an order regarding the trustee's motion for turnover and objections to exemptions and debtors' request for return of funds. Are you telling me that you never received this?
I will look in a moment. I have every single filing that I have received.
Well, I'm looking at, it's on the docket. I also have the notice of receipt, and it has you, Andrew W. Shalaby, Andrew@eastbaylaw.com. That's the official record.
I do, and I'd like to show it to the court. I'd like to show the court what I received.
I've got a copy right here. I printed it off the docket, and I have the proof of service on you.
What I have, and I'd like
I
to
don't know what you have, Mr. Shalaby, but I have the official court record, and I have an order entered the very next day, and you were served with it electronically. And now you're trying to argue to the court that you've never seen this? If that's the case, that you're not getting on and looking at the court's official docket.
I am looking at a document. It is document number 152, and it is entirely blank, and I'd like to show it to the court.
I don't know what you have on your computer, but I printed off from the court's computers the official docket, and I have a 2-page order. It's docket number 152, and I will read it. The trustee's objection to claims of exemption and request for turnover of assets came on for hearing before this court on October 1st, 2014. In addition, debtor Nakuta's request that the trustee return $30,000 of sale proceeds and $600 for costs of an appraisal to the debtor came on for hearing at the same time and place. Appearances were made stated in the record. The court, having made its findings of fact and conclusions of law on the record, it is hereby ordered: 1. Each of the trustee's objections to debtor's claims of exemption is sustained. 2. The court denies debtor's request that the trustee return $30,600 to Nakuta. 3. Debtor shall turn over A, the $600 in cash, B, the $2,741 accounts receivable collected post-petition, and C, the $211.29 from the Fidelity account to the trustee within 10 days of this order. It is docket number 152, filed on October 2nd, 2014, and on the court service list on the notice of recipients, it has you, Attorney Andrew W. Shalaby Andrew @eastbaylaw.com. That is your official address with this court.
Your Honor, if the court could please take a look at document number 181 that I filed with the court. First, to answer the court's question, do I have document number 154 as the court just read? The answer is no. I have a blank document on my computer. What I explained to the court on document number 180 is that I had a computer breach. I explained to the court that I had the United States Secret Service at my home, and they got through all my computers because somebody got into my computers and apparently sent threats to the president. They showed up with subpoenas. They showed up with 6 vehicles. I have since had several instances where ECF filings didn't make it through, and what I gave to the court in evidence is attached, I think, to document number 180, where I'm getting notices back from the court saying that the delivery is not making it through. What I'm trying to ask the court to look at is document number 152, which is entirely blank. It's got a white border on top, a white border on the bottom with a bunch of text, and yellow in the middle. So no, I didn't know about that order. I didn't know anything about it, and it was not intentional. I didn't do anything intentional, Your Honor. But nevertheless, I would like to also address the merits on the order to show cause with regard to the $17,861 we're talking about, because I still maintain, Your Honor, that that is a wage, a disposable income, and that the trustee shouldn't have those funds. And I disagree. I think the court made a mistake, and I'd like to talk about it, because it's one of the issues on the order to show cause. It's issue number 3 on document number 165. Again, we look to see whether my objection had merit, that it was untimely, under Federal Rule of Bankruptcy Procedure, Section 4003B. In making that determination, the court would examine document number 118, and it would compare it to document number 124-1, and the court will note that it's not raised on document number 118. The court will note that there's no objection by the trustee as to wage versus disposable income. No talk about independent contractor. I believe the objection has merit, but let's assume that it does not. We'll move on to the next stage, which
We're going to stay with the first point that I'm addressing, and that was point 1 of the OSC. The court has carefully reviewed your papers, has listened to you here today, and the court is still of the opinion that counsel has insistence on advancing arguments that were not warranted by existing law or by non-frivolous arguments for the extension, modification, or reversal of existing law or the establishment of new law. Furthermore, counsel has demonstrated a failure to ensure that the allegations and factual contentions he advanced had any evidentiary support. They had no support whatsoever. Counsel has also demonstrated an inability or unwillingness to obtain the most basic knowledge of bankruptcy law or to engage in the legal analysis necessary to competently represent this debtor. Furthermore, the harm to the estate caused by forcing the trustee to use limited estate assets to respond to counsel's frivolous arguments and position is totally unwarranted. So let's turn our attention now to the second point, which is counsel has argued that the debtor was entitled to reduce the value of many of his assets by 50%, taking the position that debtor, his non-filing spouse's community property interest was not property of the estate. In support of this argument, counsel cited California Civil Code of Procedure section 706.050 and ignored 11 U.S.C. section 541A2.
I provided a substantive response to that issue with my filing document number 176. In particular, there are two issues. One is whether I listed it properly on the scheduled document number 101 and whether that's subject to sanctions. I presented the authority on that issue. On that first issue, I presented a Ninth Circuit decision, or Fifth Circuit, one or the other, that indicated sanctions are generally not based on that, but there has to be something else. There has to be more to it. The next issue is whether my objection that it was untimely on the part of the trustee. Again, I understand we're not looking at the objection, but I think we need to at least see whether I'm right about it. Did the trustee object on time to this issue on document number 118 or on document number 94 or on document number 61? But really the operative document is number 118. Well, no, he didn't. I think I'm right about that. The court's not supposed to entertain it yet, but the court did entertain it. Now, the second thing is the court entertained it by way of a defective motion. That wasn't even a motion. It was a status conference. It was document number 124-1. We didn't come here for a motion. We came for a status conference. There is a requirement for notice on motions. It's Federal Rule of Bankruptcy Procedure Section 9014 and the Local Rule 9014-1 and Rule 3007. As the court, if the court read my most recent filing, my supplement, Mr. Davis and I conferred about this. There's a hearing on September 3rd on that. And I said, this is not supposed to be a motion. This is procedurally defective. The court will see Mr. Davis's email response to me saying, I contend that it is not defective. We appeared, and the first thing Mr. Davis says to the court is, I recognize that it's defective. So we begin with that. That's the experience I've had so far. Mr. Davis will tell me something, it's the law, but it's just not correct. That's a big issue here. We come to the court, and the court acknowledges there's a procedural defect. It's going to give us a new hearing date of October 1 to deal with that issue. That's not a waiver of the requirement to comply with Federal Rule of Bankruptcy Procedure 9014 or 9014-1. He still doesn't comply with it. It never happens. If it's a procedural defect such as mine, and I think it's document 82 or 81, one of my documents are filed to strike a surreply, the court has no problem rejecting my filing entirely, but Mr. Davis clearly has a procedural defect that he brings to the court, and the court allowed it to go forward. It shouldn't have gone forward to begin with. If the court looks to the filings of Mr. Davis on October 28th, he's got documents 158, 59, 160. The court will see that in each instance he follows the right procedure for a notice motion. He didn't do it with this one. Now, assuming the court is okay with going forward and hearing it, Mr. Davis says there's going to be a trial and proposes a trial on his document number 146. If we look to 541A2, or the section that the court cited on its order to show cause, it says that community property is property of the estate at the time of the filing of the petition, and it explains what the criteria is in the section following there. These are questions of fact that need to be presented to the court. For example, the $17,861 was earned 7 months pre-petition. If the wife's interest vests under California law 7 months pre-petition that money, hypothetically, they have an agreement, husband and wife, that she's going to borrow the money from her family to make ends meet, and that that's going to be separate money, and it's going to be set aside, maybe not just half, maybe all $17,861 will be set aside as her separate property to pay back a debt to her family. Well, the issue then is, was it separate property or was it community property at the date of the filing of the petition? These are questions of fact that are normally introduced at trial, and the court didn't have a trial. The court stated on October 1 that it appreciated the suggestion for a trial, but didn't think that one needed to be held that day. We're talking about specifically the $17,861 Boris Metrics check, which more important than the community property issue is whether it was exempted as disposable income as a wage. That's the more important examination on that issue. But before I turn to that issue, I want to make sure that I've concluded point number 2 on the order to show cause.
Mr. Davis, do you want to respond to that?
Counsel has deflected the real issue, and now he's making a more frivolous argument, and that is he's positing a hypothetical set of facts, which we don't know what they are, that he thinks might make things community property. He went across the board across a number of assets and put 50%. So, and to now make this even more frivolous argument that there might be some hypothetical agreement between husband and wife that could possibly make that community is, I don't understand it.
On one issue, Your Honor, if the court is going to impose sanctions on the issue, again, the court is asking me, not telling me, instructing me, demanding that I not do this ever again, that it's sanctionable conduct. In fact, under Federal Rule of Bankruptcy Procedure 9011C2, where it talks about limitations on sanctions, it's the last part of this sentence I'm about to read that concerns me. A sanction imposed for violation of this rule shall be limited to what is sufficient to deter repetition of such conduct or comparable conduct by others similarly situated. So I think what the court would be saying by sanctioning this is when a debtor's attorney presents a Schedule C and files it, don't put on it that the white non-debtor spouse may have an interest that should not be allocated to the debtor. Don't put that on there. Again, the Ninth Circuit decision or the Fifth Circuit decision that I provided to the court says that's not sanctionable. What happens next after that is the trustee takes issue with it for whatever reason, and he's got his 30 days to object to it under Federal Rule of Bankruptcy Procedure Section 4003B. Has he done it? If he does, he files a motion on it, or the court could address it any number of ways, and the court can decide it. If he didn't, then it's not even before the court to be decided. That's where I'm going to rest on that issue, Your Honor.
All right. With regards to the second point of the OSC, again, the court finds that counsel continues to this date an insistence on advancing arguments that are not warranted by existing law or by non-frivolous arguments for the extension, modification, or reversal of existing law or the establishment of new law. Secondly, counsel has failed to ensure that the allegations he's made previously or even today are factual contentions he advanced at any evidentiary support, which they had none whatsoever. Third point, counsel again has demonstrated an inability or a total unwillingness to obtain the most basic knowledge of bankruptcy law or to engage in the legal analysis necessary to competently represent this debtor. And finally, the harm to the estate caused by forcing the trustee to use limited estate assets to respond to counsel's frivolous arguments and positions is further demonstrated by the arguments that are being raised here today. Turning to the court's third point of the OSC, counsel's initially scheduled and claimed exempt, quote, account receivables, close quote, from Boris Metrics in 3 amended versions of the schedules, and then when the trustee requested turnover of the receivables, counsel reclassified the funds and exempted them as, quote, wages, close quote, under California Civil Procedure Section 706.050 on 2 subsequent versions of the schedules. Despite reclassifying the funds as wages, counsel did not even attempt to establish that the funds qualified under Section 706.50 and failed entirely to acknowledge or address the trustee's argument and the evidence provided in support that the funds were not exempt under Section 706.050 because the funds were not, quote, disposable earnings, close quote, that are, quote, subject to levy under an earnings withholding order, close quote. Again, again, counsel erroneously assumes without argument that the alleged income did satisfy the 706.050 criteria.
Has the court read document number 183, the declaration of Farouk E. Nakuda, in response to this?
The court has reviewed Mr. Nakuda's declaration, which was filed on the 14th of November as docket number 183.
That issue is addressed. That issue is addressed with exhibits, with factual recitals under penalty of perjury. That issue.
Where was this declaration when the motion was heard on October 1st?
It wasn't supposed to have been a trial. Mr. Davis said it was.
There was no need, because based on the evidence before the court at that time, there was nothing to substantiate the argument you were making.
I was expecting a trial. I brought him with me, and I brought the exhibits with me on a motion that, again, didn't even have a notice on it. But I was here to do that on that day, and the trustee now has $17,861 that he shouldn't have. That's Mr. Nakuda's money.
Counsel, again, this is not a motion for reconsideration, and this is not an appeal of the order that is final. An order was entered from the bench on the 1st, and a written order was entered on the docket on October 2nd, 2014. There was no timely motion to reconsideration, and there was no appeal. It is a final order.
I'm not appealing the order, but I have an order to show cause on that issue, and I'm going to respond to it. I cited the case law on paragraph 11 on document number 183. I've cited the facts, and I've presented, in addition to that, my own personal experience in state court litigation in dealing with the question of independent contractor versus employee. And in fact, in that litigation, I was dealing with allegations pertaining to a real estate agent or two real estate agents who actually had a contract, an independent contractor agreement, and had to pay a lot of their own costs and expenses as real estate agents working for a company called Mason McDuffie Real Estate. And the question was presented to who is now an appellate judge, Honorable Sandra Margulies, in the First District Court of Appeal. But back at the time that the issue was raised, the court examined those factors that are necessary to be examined to determine if he is a wage earner or whether he's an a 1099, an independent contractor. Those factors are all presented on document number 183. Length of employment, 7 months. Show up to work every day, the schedule, the location. He doesn't live in Los Angeles. He has to be in an LA office, and he has to work out of the office, and so forth. I've reviewed the court's order to show cause. I've reviewed the court's authorities. I've reviewed document number 124-1. I've reviewed case law. I still reached the conclusion that Mr. Nakuda's $17,861,000 check from Boris Metrics was exempt, disposable income, falls within the means test, should not have been turned over to the trustee. I don't see it on the objection. I think I'm correct about that as well. Now, I'm telling the court my point of view, my belief, and why I did what I did. If the court disagrees with it, that's not a basis for sanctions. That's a disagreement that normally the Court of Appeal will have to resolve, and apparently they will on this matter. On this, it's not going to be appealed because the time to appeal has expired and because there was no motion for reconsideration. But it is raised in order to show cause. And it's an important issue if you're going to issue a sanction against me for advancing exemptions and rights of debtors that they're entitled to under the law. I have a hard time thinking that I need to not do that next. I have nothing more to say on that issue. I'm ready to proceed to the next.
Mr. Davis, do you have anything you wish to respond on the court's third point?
No, Your Honor.
The next point
Mr. Shalaby, what strikes me as odd here is that before this OSC was issued, you didn't take the time or the energy to carefully review the law or the facts of the case. And only when this court issued an OSC to potentially sanction you monetarily have you taken any time to do any type of meaningful research.
The court says that. That's completely not correct, and I'll tell you why. I didn't just research it. knowing that I was dealing with Mr. Nansdorf from the day I filed this petition, I got on it. I really got on it because we've had a history for several years. I presented a motion on that. I reviewed the law. I reviewed the cases very carefully. What I'm concerned about, Your Honor, is the court has so much trust and so much faith in Mr. Davis and Mr. Nansdorf that without question the court reads his authorities and believes it. And that is F. Nielsen. When we talk about tools of the trade, one of the court's points. Point number 5, I didn't respond to the trustee's authority. And that is the F. Nielsen case that says money in a bank account is not tool of the trade. And let me tell you how disturbing that is. The court wants to sanction me for taking my position on this issue. But the authority itself facially is defective. It doesn't have the volume for the citation. The name is not correct. And worst of all, before the court reaches a conclusion that an attorney needs to be sanctioned for claiming that money in a bank account is exempted as tool of the trade, the court should at least read that authority. And it's the superior court, lower court authority that's not binding on any court in the state of California. It's a municipal court decision from 1992 that was appealed to the appellate division of the Los Angeles Superior Court that is not binding on any other court and doesn't even say that money in a bank account is exempted in every circumstance and situation as tool of the trade. I presented the court with the proper authority on this issue, and I still believe very firmly that money in a bank account is absolutely tool of the trade. And the authority is on the briefs here. If you need money to pay your water, if you need money to pay your employees, to service the machines, to pay the landlord, it's a tool of the trade. And it says it's a common sense pragmatic analysis, and the case I think is Comer from the year 2011. I'm being accused of not doing the legal research, but the court took Mr. Davis's word for it and shouldn't have. It's just wrong.
Mr. Davis, I think there's a pleading that Mr. Shalaby acknowledges in writing the numerous errors he's committed in this case.
He not only he did it in pleadings, in correspondence, on the record, in a deposition, except when an order to show cause is brought against him, then he doesn't admit anything.
On that pleading, I explained to the court that I had some personal issues that I wanted to talk to the court privately about. Does the court recall that?
Your opportunity to present any response to the court's OSC was due in writing, filed by November 14th of this year.
It's been done, and it's before the court. And let me tell you what it is. On March 10th of this year, you issued a disgorgement order of $50,000 against Attorney Basil Boutros in Fresh Choice. You ordered him to turn over $84,000. I read it. I heard the audio. I was terrified with what you did in that case. I don't agree with your point of view. I don't agree with the law, and I don't agree with what you told him in court, that you were trying to tell him to admit it. You were pushing him to admit that he did something wrong on that. I was so deeply troubled and so scared by what you did in that case. I read the same decision that came from the BAP on March 4th of this year, where you wanted him to disgorge $2,043 or so, and the bankruptcy panel ruled that you can't use 11 U.S.C. Section 504 to do it because you need an order, and it has to be a violation of the order and that sort of thing. And I was, again, very scared and concerned to such an extent that I filed a subsequent pleading with this court saying, I don't want to come here today. I don't want to argue and explain to the court that I disagree with the court. I just want to pay the $4,000 disgorgement and go on with my business. I disagree with the court, and I'm scared of the court.
Shalaby, I don't know what relevance those other cases have to do with anything with this case.
If the court is going to issue a sanction against the attorney and go through the trouble of publishing on Westlaw, and it's going to be something that extreme, you see, a sanction, especially in the Chapter 7 case where you're ordering a disgorgement, you're asking an attorney to turn over his income, his check, I view that actually as potentially a Fifth Amendment takings violation. This is money that's already been earned, and you're telling the attorney, I want you to give it to the trustee because you did something wrong. You know, I presented the authority from the United States Supreme Court brief on my filing as to when a court should impose sanctions and why the court needs to be careful with doing that. Because the court is taking money away from somebody that he needs to support his family, his wife, his children, his mother, and the court's giving it to a trustee. And the court is telling him in the process of doing that, I don't want you to do this again. You're wrong for doing this. Rule 11 says you have to have a good faith basis for what you're presenting or a non-frivolous argument for presenting it or something like that. Before a court does that, the court needs to do its part too. Tools of the trade, bank accounts are not exempted. Money in the bank account is not exempted. You're going to get sanctioned for it, don't do it again. What if I'm right? As a matter of law, what if I'm right? I've been sanctioned not to do it again. These kinds of things, they don't get dealt with in sanctions. They get dealt with in the Court of Appeal. And in this particular case, there's one thing that just really troubles me immensely. And it's what happened on April 17th. I told the court on September 3rd, I've been wanting to talk to the court for a long, long time. It's the shutting down of the businesses. It's the employees that didn't get paid. It's the landlord who didn't get paid. It's Eastern Funding that didn't get paid. It was shut down within 2 hours and 29 minutes of the date that they filed an ex parte application. It's up on appeal on that issue. That one really disturbs me because one could say I don't know bankruptcy law. I don't have experience. I don't do my legal research. I know one thing. Under California Section 1708, the trustee has a duty not to be negligent, not to hurt innocent people and families that have to support their children and landlords that have mortgages that they have to pay. And to come in and to say in every single filing, when you've got a DBA, you've got to shut it down before you turn it over. Give me some authority. Don't just say it because I'm stupid and inexperienced. Give me some law on that. Give me some...
Mr. Shalaby, I don't even know how to begin to address the comments you have just made to the court, citing cases that have nothing to do with this matter before the court today. You've clearly demonstrated total ignorance of the law dealing with Chapter 7 and what a trustee's responsibility is having to do with an ongoing business in order to protect the state from incurring additional expenses under a lease, wages, workers' comp, potential liability for injuries on premises where there may or may not be insurance that would expose the estate to having to pay those expenses or damages to the detriment of the creditors of the estate. You have clearly demonstrated to this court you have no concept of Chapter 7. With that being said, on regards to the point number 3, the court can only determine that, again, your insistence on advancing arguments that are not warranted by existing law or by non-frivolous arguments for the existence, modification, extension, modification, or reversal of existing law or the establishment of new law. Again, in the papers that were filed, there's a failure to ensure that the allegations and factual contentions you've advanced had any evidentiary support. Clearly has demonstrated the court an inability or unwillingness to obtain the most basic knowledge of bankruptcy law or to engage in the legal analysis necessary to competently represent this debtor, and you've harmed the estate because you've caused the estate to force the trustee to use limited estate assets to respond to counsel's frivolous arguments and positions, which are further demonstrated and highlighted today. I'm now going to move on to the 4th point, which was in response to the trustee's objection to claims of exemption, counsel alleged that the trustee had not identified any assets in dispute, despite the fact that the trustee had filed timely objections to various exemptions. Counsel had been served with the objections, and the memorandum of points and authorities filed with the objections were set for hearing, identified the assets at issue.
The objection is document number 118. The trustee moved on it, and that would be document number 124. And I am correct.
That's it?
Yes.
Mr. Davis, do you have anything you wish to add?
No, Your Honor.
With regards to the point 4 of the OSC, again, counsel continues his insistence on advancing arguments that were not warranted by existing law or by non-frivolous arguments for the extension, modification, or reversal of existing law or the establishment of new law. Counsel's failure to ensure that the allegations and factual contentions he advanced had any evidentiary support. They had none whatsoever. Again, counsel continues to an inability or an unwillingness to obtain the most basic knowledge of bankruptcy law or to engage in the legal analysis necessary to competently represent the debtor. And as a result of these positions taken by Mr. Shalaby, it has harmed the estate because the trustee has had to use estate assets which are limited in order to respond to counsel's frivolous arguments and positions. Next is point 5. Counsel claimed debtors' bank accounts as exempt, quote, tools of the trade, close quote, under California Civil Code of Procedure Section 704.060. In his objection to the claim of exemption, the trustee cited case law that held that under California law, bank account proceeds may not be claimed as exempt as tool of the trade. Counsel's response to the objection failed to address the merits or respond to the trustee's argument.
The citation presented by the trustee is not an authority. It's cited incorrectly. It's got the wrong name. It's got the wrong volume number. It doesn't stand for the legal point of view that he's presented and advanced before the court. It's not a binding authority. It's from a superior court. It's a 1992 decision from a municipal court case involving Attorney Andrew Shalaby, who was trying to exempt his bank account relating to a law practice, and under the facts of that case and under the facts of that case only. This is an issue that's going to come up before this court time and time again. The court is taking the position, and has taken the position, that money in a bank account is always not a tool of the trade. This is a higher court than the Nielsen court. That decision itself could be binding, and that would be a precedent across the state of California. It needs to be the law. It needs to be correct. Again, I reviewed the law, I reviewed the authorities, I reviewed the cases. I went on to Westlaw, I put down tools of the trade exemption, I pulled up the statute, it has notes of decision, and I looked through the notes of decision. I researched it independently, and what I find is what I presented to the court. I am not finding any case law or authority that supports that money in a bank account can never be deemed a tool of the trade.
All right. Mr. Davis, do you wish to respond?
No, Your Honor.
All right. Again, with regards to this 5th point, counsel again insists on advancing arguments that were not warranted by existing law or by the non-frivolous arguments for the extension, modification, or reversal of existing law or the establishment of new law. Counsel's failure to ensure that the allegations and factual contentions he advanced had evidentiary support. Again, they had none whatsoever. Counsel's inability or willingness to obtain the most basic knowledge of bankruptcy law or engage in a legal analysis necessary to complete to represent this debtor. And furthermore, the state has been harmed as a result of having to use limited estate assets to respond to counsel's frivolous arguments and positions. The court turns next to point 6 of the OSC, which is as follows. The trustee did not object to the homestead exemption of debtor claimed in his residence, and in fact negotiated a sale of the non-exempt equity over and above the $100,000 exemption back to debtor for $30,000. The negotiated sale was properly noticed out. Debtor paid the $30,000 to the trustee, and the court approved the sale by order dated July 23, 2014. Mr. Shalaby, did you get that order?
Yes.
The order was never appealed and became final. Despite that, in connection with the hearing on the trustee's objection to debtor's exemptions, counsel argued that 1. Debtor had now obtained an appraisal of the residence. 2. The actual value of the residence was less than the trustee had asserted. 3. The trustee had not objected to debtor's homestead exemption. And 4. As a result, the trustee should return the entire $30,000 and pay debtor $600 appraisal fee. The request was denied as frivolous and procedurally improper. What do you have to say?
Unlike the other issues, which I just mentioned, where I think that the court needs to be correct, Otherwise, it shouldn't sanction it because that could be a problem. It could set a precedent. On this particular issue, I've already explained to the court what I'm willing to do in the future, but I'm going to go to the merits as well. I explained to the court that if the court thinks it's inappropriate to do that, I simply will not do it in the future because there's a remedy to it, but now on the merits. On page 8, document 176, which I filed in response to this point, I point out that a trustee's duties under 11 U.S.C. section 704 include the duty to investigate the financial affairs of the debtor. I pointed to subsections 1 and subsections 4. It's a bankruptcy. In a bankruptcy, you have no settlement document that's signed with a 1542 waiver that says that you're not going to pursue any redress with the court before final distribution of the funds, that you are precluded from presenting evidence to the court anywhere along the way that the trustee came up with a false or very artificial and unsupported valuation of the house and did it for reasons that shouldn't have. In this case, actually, he did it because he was angry.
Because it was what?
Because he was angry. Angry. The trustee was angry.
Angry at what?
He was angry at me. This was many months after I filed the petition, mind you. I filed the petition on March 16th. No talk about the house. April, May, a long period of time, no talk about the house. We're having a bitter exchange. We're having a deposition. We're having disagreements. And the trustee gets angry. Mr. Davis gets angry. And then returns to the house. I'm going to teach you a lesson, Mr. Shalaby, and I'm going to teach your client a lesson too. We're going to show you. We're going to go out. We're going to make him buy this house back. We're going to take it. We're going to sell it. It was valued properly. Actually, it was overvalued. I valued that house very carefully.
Mr. Shalaby, this was a consensual settlement between the trustee, the debtor, and you were representing the debtor.
Mr. Nakuda is making a request if you could address the issue.
No, you're the attorney. This is an OSC directed at you.
Okay. I need some case law or some authority or some law or some case that says when you don't have a settlement, this is not a settlement. You just have a trustee who says this is the value and the debtor says I'll pay it. And the court approves it. What does that approval actually mean? It means, yeah, the court's approved it. You can go ahead and do that. But does that approval extend into saying you're also precluded from coming back and having the court examine the value to determine if you overpaid for it? I don't think it is.
Mr. Shalaby, this is just so, I don't know how to respond to the arguments you're making. They are so off the wall. I don't know how to better describe them. It was a consensual settlement. The court approved it. Your client paid the money, and after the fact, you want to go back and revisit it and say, give me my $30,000 back, and oh, by the way, pay me $600 because I, after the fact, decided to go get an appraisal, and now I've got buyer's remorse that I voluntarily settled. When you come back seeking the recovery of those funds, how can you in good faith justify that?
If you disagree with me, Judge, sanction me, but sanction me properly. Don't over-sanction me, and let me deal with it after that. But, I mean, the question is how much harm and how much damage and how much work did Mr. Davis have to put up into that issue? I don't even know if it was one sentence on his brief. See, that's the thing. How much burden and time and money did it cost the estate? For me, I didn't bring a motion. I presented it as a sentence in document number 146. If the court disagrees with me, the court looks to see how much harm has that caused. But don't sanction me because you're angry at me. Because
I'm not angry at you. I have no personal animosity towards you at all. I am just astounded with the way you have conducted yourself. In this case, the manner in which you've communicated with the trustee, this court, and how you have not properly represented your client.
I understand.
All right, anything else with regards to the point 6 of the OSC?
No.
All right, this is probably one of the most egregious points of the OSC. Again, Counsel, even to date, insists on advancing arguments that were not warranted by existing law or by the non-frivolous arguments for the extension, modification, or reversal of existing law or the establishment of new law. The response counsel makes is he asks this court to advise him of what the law is. That is not how it works, Mr. Shalaby. Furthermore, counsel has demonstrated a failure to ensure that the allegations and factual contentions he advanced had any evidentiary support. There was absolutely none, and you'd have to visit Fantasyland to find any factual support for this type of an argument. Next, counsel again has clearly demonstrated a total inability or willingness to obtain the most basic knowledge of bankruptcy law or to engage in the legal analysis necessary to competently represent the debtor. And the state has been harmed by forcing the trustee to use limited estate assets to respond to counsel's frivolous arguments and positions. I next turn to point number 7. Counsel advised debtor and argued to the court that despite demand by the trustee, debtor had no obligation to turn over assets because counsel had determined that the assets were of inconsequential value or benefit to the estate under 11 U.S.C. section 542. In making this argument, counsel failed to address or even acknowledge the existence of section 521A4, which mandates turnover of all property of the estate. Counsel also appeared unaware that a finding of, quote, inconsequential value or benefit to the estate, close quote, is not made by the parties on their own, but by the court after a properly filed, noticed, and served motion.
I am a little bit troubled that the court has taken what Mr. Davis said as true. Where is the evidence that I told the debtor not to turn anything over one item? There is none. It never happened. But the court has taken Mr. Davis's word for it. Now, to the extent that we're talking about 542A, 11 U.S.C. section 542A, I sat with Mr. Nakuda and I reviewed that section and 541, which the court also just mentioned, and then I printed it, and then I handed it to him so that he would know what it says. And the items at issue on document number 124-1 are on page 1 and page 2 of that document. Not a single one of those items did I tell him not to turn over, but you know what's more important than that? Nor was he asked to turn it over. See, that's the thing. Was he asked to turn over the $600 in his wallet? No. The $3.11? No. None of that money. And in addition to not being asked to turn it over, again, it's not even presented on his objection. The trustee's objection, document 61, document 94, document 118. They're not on those documents. So I don't know what to say. I don't know how to respond to that. The fact of the matter is I did not tell the debtor not to turn anything over, and he was very compliant. You know the $17,861 check? Hello, Mr. Davis. He received a check. I want that money. He gets in his car, drives over to his office, and hands it to him in his hand, uncashed. I'm just disturbed that the court has taken these allegations as true and is going to sanction me for it.
Mr. Shalaby, under 11 U.S.C. section 521A4, it says, if a trustee is serving in the case, as this case is Mr. Mansdorf, is surrender to the trustee all property of the estate and any recorded information, including books, documents, records, and papers relating to property of the estate, whether or not immunity is granted under section 344 of this title. Are you telling me that when this case was filed, Mr. Nakuda turned over all of the assets of the estate to the trustee?
Give me a moment to remember. The $3,719 in the bank could not be turned over because it had been paid to Sean Shafiq.
Pardon me? It had what?
Could not have been turned over because it had been paid to Sean Shafiq.
When was it paid to?
Pre-petition.
Okay.
It was a check and it was uncashed.
All right.
And there were other funds, I think maybe $2,000 or something like that, that were included in that $5,000 check to Mr. Shafiq. The trustee has presented to you on October 1st that in contempt he didn't turn it over. And Mr. Nakuda tried to explain to you, yes, he did. You didn't let him talk, and you turned to Mr. Davis, and you looked at him, and you said, my understanding was that it was not turned over, but you didn't look at the statements. They're attached to Mr. Nakuda's declaration today. So I'm a little bit bothered by that. As far as other assets that belong to the estate, I have to think of the assets on document number 124-1.
Well, let me do this. Mr. Davis, what were the assets that were not turned over to the estate that you had to make demand and fight to get those turned over, if they have in fact been turned over to? Maybe you could refresh Mr. Shalaby's recollection.
Well, Mr. Shalaby knows. I'm surprised to hear him say that there wasn't anything in the bank because it had been given to Mr. Shafiq. Mr. Shafiq was given a check pre-petition that cleared a month post-petition. There was the money that's been the subject of these motions. It's clearly documented, was $3,000 some odd in the bank. It's never been turned over until very recently. Some portion has been turned over after the court's recent order. And I'm troubled by Mr. Shalaby claiming he never saw that order, because he contacted me when the deadline under that order ran to let me know that that the debtor was going to make the deadline, but he might be a day late. This is months after. Nothing was turned over voluntarily. I think that's the easy way to look at it. Not a thing. Nothing was voluntarily turned over ever. I had to fight for every penny, and it's as simple as that. But to misrepresent that there was nothing in the bank, that's a false representation yet again today. The record is clear. There was money in the bank on the day of the petition. Even the schedules admit that. But now he's claiming it was given to Mr. Shafiq, who received an uncashed check pre-petition.
First, my name is Shalaby, not Shalaby. Mr. Davis is taking the position that because the money was in the bank account because the pre-petition check had not been cleared yet, he needed to turn it over. Now that, to me, is not logical. If you wrote a check pre-petition to somebody and the money hasn't been cashed yet, I don't see how you could turn it over. I don't see that as appropriate, but if the question is to ask him to go in there and see if the check cleared, and if it didn't clear, to turn over the funds.
Mr. Shalaby, that's what normally a competent attorney would do before filing the case. If he was concerned about a check clearing the bank, he would get a current bank statement or check with the bank, and he'd either hold off filing the case until the check cleared, or if it hadn't, he'd tell his client, issue a stop payment, and those funds then need to be turned over to the Chapter 7 trustee immediately. That's what a competent attorney would do representing a debtor.
If that's what a competent attorney would do representing a debtor, and if that's what most attorneys do in Chapter 7 bankruptcies, then the court's going to be correct on that issue. As I sit here today and ask myself the question, on my next bankruptcy, I have somebody who's written checks on his mortgage or whatever. He's written checks for whatever. And I filed a petition and some of those checks haven't cleared. Do I tell him, freeze your bank account and do nothing and wait until all these checks run through and then we'll file the bankruptcy? Do I tell him, stop payment and turn over those funds? And do I get sanctioned for not doing it? I don't know about that. I just don't know.
Your Honor, just point out, counsel doesn't appear to understand the law in this circuit that whether the money's been spent post-petition isn't a defense. Turnover is what's in the bank account on the date. Counsel either doesn't know or doesn't acknowledge that established law.
Anything else, counsel?
On this issue?
Yes.
The court asked the question of Mr. Davis to specify the items. The only item I'm hearing about is $3,719, and it hasn't even been decided yet because the appeal is still pending. Is there another item that I need to address?
It's your opportunity, counsel, if you wish to add anything.
I want to talk about the laundromats.
Go ahead.
The laundromats were not shut down and turned over. That was the biggest issue in this entire bankruptcy. When I filed this bankruptcy, as soon as I knew who the trustee was, Mr. Mansdorf, way before the 341 meeting, I sent him an email saying, this one's complicated, we've got businesses, so on and so forth. I did it so he could look at the petition immediately, and he could determine one of two things. Shut it down, I'm going to abandon it, I'm going to file a motion with the court, I'm going to do something. He didn't. He didn't do anything. I showed up at the 341 meeting. Most 341 meetings take 3, 4, 5 minutes. A long one might take 15. This one took an hour. At this meeting, I have Mr. Davis and Mr. Mansdorf. Mr. Davis, without warning, he's got a counsel. He hasn't even filed an application to hire counsel, but he's got one. And that issue comes up about the businesses, the laundromats. Shut them down, turn them over, don't shut them down, don't turn them over. And aside from the fact that the entirety of this transcribed 341 meeting was a harassment and badgering with a loud tone of voice, and Mr. Davis standing up and pointing his finger at my face and walking over to Mr. Mansdorf and saying things. Aside from that, the core issue was, do we shut down these businesses and turn them over or not? And Mr. Davis walked up to Mr. Mansdorf and whispered, tell him to shut him down and give you the keys. Mr. Mansdorf didn't want to do that at that moment. Mr. Mansdorf, at the end of this long 1-hour 341 meeting, says, Mr. Davis and Mr. Shalaby and Mr. Nakuda, go into a room, talk about what you want to do with this, turning it over, shutting it down, whatever. Go talk about it now, here today, April 17th. We step out to do that, and this one gets even weirder because now I'm being approached by Ms. Sandra Wilson, United States Trustee's Office, asking me who I am, knows my name, is handing me her business card, and already I understand that everything is under investigation by the United States Trustee's Office. Mr. Mansdorf's got an attorney, got a very long hearing. We've got to figure out what's going on with this. Mr. Davis and I and Mr. Nakuda get into the elevator. We're heading down to the 5th floor of the building to go into a room and discuss those issues. But Mr. Davis doesn't get out, so we stay in the elevator. We go down to the bottom floor. We step out of the elevator, wondering why we're on the bottom floor. Mr. Davis gets in the elevator and disappears, completely disappears. I get back in the elevator. I go up to Mr. Mansdorf's department on the 6th floor. I walk up to Mr. Mansdorf and I tell him, Mr. Mansdorf, Mr. Davis has disappeared. We're trying to discuss whether to shut down and turn over these businesses and the procedure, give the employees notice or not or whatever, and he's disappeared. Mr. Mansdorf is not telling me shut him down and turn them over. But what he did tell me at the meeting, though, was that he was contemplating making an ex parte application to do it. And he went on to say, when he does, they generally are granted by this judge within the same day. And in fact, he did just that the next day. He filed his ex parte application to turn over those laundromats. No notice to the landlord, no notice to Eastern Funding, no notice to the employees, no notice to me, no notice to anybody. Within 2 hours and 29 minutes, the court issued document number 21, ordering them to be turned over and shut down. Mr. Davis insists Mr. Nakuda didn't do that and that he was in contempt. But in fact, Mr. Nakuda took those keys, got in his car, and went straight the next day to Mr. Davis's office, delivered the keys, and they were all shut down. They were shut down promptly. They were shut down immediately.
What did Mr. Nakuda do with the money in the laundry machines, or the coin machines at the various laundries?
Give me a moment. I have to ask him, because I don't remember.
He's here. Go ahead.
Can you testify directly?
No, I'm asking you to inquire how much money he took out of the laundry machines after the petition was filed.
On the date of the petition or the week
I want to
before?
know how much money he took out after the petition was filed. There were 4 laundromats, and I want to know how much money that was taken out by him.
$25,338, and that will be shown on the flow sheet that is filed with his declaration, I believe. And
Have
it should
those
be the
funds
top.
been turned over to the trustee?
Those funds included pre- and post-petition funds, and as the court has attached to his exhibit filed before it, they were used to pay laundromat rent, salary, laundromat.
So how much did he take on? How much were in those machines on the day the petition was filed? $25,000?
At any given point in time, maybe $1,000 in the machines.
So it went from $1,000 to $25,000?
You're asking about the money in the machines.
I'm asking about the $25,000 that Mr. Nakuda took.
That's the revenue for 1 month.
All right, so he took out $25,000. Specifically, how much did he take? $25,000?
$25,338.
And he didn't turn that money over to the trustee.
No, he used it to pay those expenses shown on the document.
Under what authority did he have to use estate money to pay those expenses? Did you advise him it was fine to expend those funds?
One thing at a time, please. I'm being talked to.
Nakuda, please just ask him. Mr. Shalaby, did you advise him it was okay to take the money and expend it post-petition?
Give me a moment. I don't believe he asked the question. I don't believe I answered it because I don't believe it was asked.
Did you advise him not to expend any estate funds after the petition was filed then?
I advised him that he needed to turn over to the estate funds that belong to the estate, and I gave him 11 U.S.C. section 542A and 541. I printed them and gave them to him. But did we actually get into a discussion to determine what belongs to the estate and what doesn't belong to the estate? I think we did. I think we got into that discussion. And did I specifically advise him not to pay the laundry rent and the salary and insurance and the items shown on the document? He didn't ask me that question, and I didn't talk about it. I talked about what a bankruptcy means. I talked about pre-petition, post-petition, what belongs to the bankruptcy estate, what's exempted. Some of these issues, we have a disagreement as to what belongs to the estate. I don't know about this document. I don't know about these members here. But some of these issues, like the $3,719, of which a portion belongs to the partners, it belongs to the non-debtor partners, and we have disagreements about that. When we look at the $25,338, some portion of that belongs to non-debtors as well. So the answer to the question is, I generally explained to him what it means, but I didn't go item by item on these things.
All right, anything else?
No.
On point number 7, counsel has clearly indicated to the court in his continued insistence on advancing arguments that are not warranted by existing law or by non-frivolous arguments for the extension, modification, or reversal of existing law or the establishment of new law. Counsel, again, has clearly demonstrated an inability or total unwillingness to obtain the most basic knowledge of bankruptcy law or to engage in a legal analysis necessary to competently represent the debtor. The court finds out today that apparently the debtor has taken some $25,000 that appears to be money belonging to the estate and expended it without court authority or trustee's approval. There's no question that the estate has been harmed as a result of any of the expenditures of those estate funds, and furthermore that the trustee has had to use limited estate assets to respond to counsel's frivolous arguments. Mr. Shalaby, the other question I have for you is, do you have here today, do you have all of the original signatures?
I have them, but they're scanned, and I have them on the computer, and the computer's in front of me.
So, at the time you prepared and had the schedules filed with the court, did you actually obtain Mr. Nakuda's signature on those documents?
No.
When did you obtain his signature?
As I stated on his declaration or mine about a week ago.
All right. So after the fact, you've had him sign these various documents?
I did, after the fact.
Even though those documents have been amended several times to correct errors?
Yes. He did not sign the documents at those points in time.
Did you ever afford him the opportunity to review the documents before they were filed with the court?
Absolutely. And he reviewed them carefully, and he made changes, and the trustee asked at the 341 meeting about it, and he confirmed it. And the trustee asked, did you sign these documents? And he said, yes, but I had explained to him before that in federal court we have electronic signing, and I explained the procedure for the electronic signing, / and so forth. What I didn't know, just as Mr. Singh didn't know, and Mr. Dhaliwal didn't know, was that you needed to keep wet signatures too. In federal court, you don't. In the Ninth Circuit, you don't. In bankruptcy court, there's a local rule.
This is a federal court. This is in the Ninth Circuit. And in the bankruptcy court, you are required to have the original signature at the time you make the filing, and you're to keep it for a period of time. It's clearly set forth.
What I was trying to explain to the court was the reason that I made the mistake of not getting a wet signature is because the majority of my law practice is not bankruptcy. It's federal court litigation, state court litigation, Ninth Circuit, and even United States Supreme Court. And in the federal court, but not in the...
Mr. Shalaby, that's not an excuse. That's just ignorance, laziness.
Your Honor, I have submitted a declaration before the court. On that declaration, unlike Mr. Dhaliwal, I come forth...
I don't know what Mr. Dhaliwal has to do with these proceedings here today, Mr. Shalaby. You keep referring to other matters. They're not before this court. They have no relevance whatsoever as to your conduct.
I'm referring to the bankruptcy appellate panel on that case on March 4th of this year that says on it it's not published, but it could be cited for persuasive authority because the court's familiar with it, having participated directly with that one because it was the same issue. It was the same violation. And how do we handle that? And what's appropriate to do on that issue? Well, what I'm trying to explain to the court is I've been honest and forthcoming that I made this mistake. I didn't try to hide it. Mr. Dhaliwal did, and the court took issue with it. Bankruptcy appellate panel took issue with it. On that particular issue, there are 3 applicable statutes for remedies available to the court cited on the court's order to show cause. 11 U.S.C. Section 105 is not. The bankruptcy appellate panel indicates that under that provision the court issues an order and there has to be notice that if it's violated there's going to be a consequence to it. The bankruptcy appellate panel did come back and say that the court can enforce its local rules, and then in that case there were other issues, big issues that had to do with why the court did what it did, $2,000 with a time period to go up to $10,000 and so forth. Disgorgement, Section 329, does not appear to apply for that. 11 U.S.C. Section 9011 may apply to that. What is an appropriate remedy? What is an appropriate sanction? Under Rule 9011 C2, the limitation, a sanction imposed for violation of this rule shall be limited to what is sufficient to deter repetition of such conduct or comparable conduct by others similarly situated. On my declaration, I indicated to the court that it was an innocent mistake that would never happen again. In the same case, the court suspended filing privileges and required the attorney to take ECF training for 90 days. In this instance, it was an innocent mistake as to one procedure that has since been corrected that will never happen again. Other than that, I adhere very, very carefully and strictly to the court's procedure. On the issue of procedure, my feeling is if the court is going to impose a sanction, that the court should look to see if it was an intentional act on my part or an accidental mistake on my part. I cannot deny the fact that the bankruptcy local rules require a wet signature. I didn't know about it. and I didn't do it.
All right. Anything else?
I want to address the overall issue of sanctions, the three statutes. Under 11 U.S.C. Section 105, which the court cites, I don't think that that's the right statute. I think that that statute is inapplicable for the reasons that are explained in the Singh action. I think generally that's the court's inherent authority to make sure that everything goes smoothly and expeditiously and so forth. And generally what the court does is it issues an order, and if it's violated, there's going to be an imposition of sanctions. That's never happened. In the entire course of this proceeding, as a matter of fact, I've only filed one motion. It was the motion to remove the trustee that I withdrew later. I didn't file multiple motions. The court didn't issue any order that I disobeyed. So
Is that the motion you filed after making a demand upon the trustee?
for
I
75?
believe that you made a demand upon the Chapter 7 trustee on behalf of Mr. Dakuda to pay him $75,000 in relation to the Fulton Street. And you also were putting the trustee on notice that you would be asserting a claim with regard to the Vallejo property once those losses move past a speculative realm. Is that the motion that was filed?
No.
That threat was made before you filed the motion to remove the trustee or after?
After. I filed the motion to remove the trustee fairly promptly after what occurred at the 341 meeting. I want to talk about what you just said, though. Two things bother me about that. The first is that in order to show cause, the declaration of Mr. Davis with these issues that are not on your order to show cause is not supposed to be looked at or considered. That would be a separate
Mr.
motion.
Shalaby, I don't necessarily disagree with that. The point is you just brought this issue up about
Okay.
the motion to remove the trustee. So based on that, I'm commenting on what I know about the record.
The fact of the matter is,
The OSC is limited to what I issued it and the points we've addressed. So my question is there anything else you want to address the court with regards to the court's OSC? Because that's what's before the court today. Nothing more, nothing less.
if the court's inquiry is limited on that issue that the court just mentioned, to determining whether I first threatened to sue the trustee and then I filed...
What's before the court today is simply the OSC and those points raised in the court's OSC. That's all that's before the court today. You're the one that brought up the motion to remove the trustee that you filed and then withdrew. I didn't bring that up in the OSC. You brought it up today on your own volition.
Okay, on that one issue, let me just say. It remains my very strong and deep opinion that the trustee would indeed have liability under California law, Civil Code Section 1708, and that he has done things in this case that have hurt the creditors, that have hurt employees, landlords, secured creditors, things that are very, very improper, that actually would warrant his removal. But I withdrew that motion because it was pretty clear to me that it would never be granted in this court. And I was going to have a very bad day if I came to appear before this court on that motion that day. The question is, back to the sanctions. I don't believe 11 U.S.C. Section 105 is the appropriate section. The next one is Section 329, disgorgement. Disgorgement is focused on compensation to the attorney exceeding the reasonable value of services. That's the focus of it. It's not a sanction from what I could tell. It's a disgorgement. On that particular statute, I think the court would inquire to see if the $4,000 total that I received in this case was disproportionate to the services rendered. To the extent that
Do you believe that there's any serious consideration over that?
Do I believe that?
It was a rhetorical question, Mr. Shalaby.
Give me a moment to think about that.
Yeah, we can move on. What else do you have?
I have to answer that question. I think the court's wrong. I think, Your Honor, you are incorrect. I think that you are asking me to adopt your belief of the definition of tools of the trade. I think you're asking me to adopt your interpretation of the law with regard to the $17,861 that you and I seem to disagree about, that I think should have stayed with the debtor. And I think that you want to have me penalized, whether you call it disgorgement or sanctions or something like that, due to a disagreement between you and I. I think that the amount of services rendered vastly exceed $4,000. We've had a deposition of Mr. Nakuda with the trustee, and we had another 2004 examination with the United States trustee. The amount of hours expended in defending Mr. Nakuda's interests entirely independent of the issues before the court today vastly exceeds it. So as to whether I think the remedy should be classified under 11 U.S.C. Section 329 or not, as a matter of law, I think not. I think it would have to be under Federal Rule of Bankruptcy Procedure Section 9011, the sanctions statute that mirrors Rule 11. On that particular issue, I have cited to the United States Supreme Court case Cooter and Gell versus Hartmarks Corporation, 496 U.S. Section 384, page 408. When the court is looking to impose sanctions on counsel, it's not proper for the court to sanction a counsel for a disagreement with the court on case law, on authority, on whether you need to have a noticed motion for a turnover, or whether it could be ex parte application, or whether a bank account is a tool of the trade or is not a tool of the trade, or whether a monetary item is a wage and not an account receivable. I don't think that that's an appropriate use of the sanctions statute, in particular because it shows a First Amendment right, my First Amendment right to represent my client and advance his arguments competently before the court, and Mr. Nakuda's right to present his case and his exemptions and his reasons why he believes these funds shouldn't be turned over, these are his funds, these are not his funds, and so forth. What the court does focus on when it's looking to impose sanctions is repeated advancement of arguments that are frivolous. There's no good faith for it, no good faith for the belief. Somebody who's filed a motion and lost it and filed another motion and lost it and just keeps on persisting, that certainly didn't happen here. Willful misconduct, misconduct in bad faith, absolutely that did not happen here. In fact, everything boils down to a disagreement between myself and the court, largely on most, maybe all the issues, with the exception of the ECF issue, which was a mistake. My biggest concern, my biggest issue, Your Honor, with the order to show cause having me appear here today to respond to the 7 points mentioned on document number 165 is that largely I believe that the court is of the position that the arguments that I am presenting to the court are not only wrong, they're unsupported by law. There's no good faith basis on my part to believe it. Had I known the law, had I been a competent attorney, this wouldn't have happened. But on the order to show cause, the court doesn't present any authority or statute or basis for those statements, and again, in particular, the one of the big ones is tools of the trade. That's a big one to me, because a lot of these issues turn on that one, and on the wages too, and on the objections as well, actually. For the court to take the position, I've heard what the court had to say once we rested on point number 5, tools of the trade. The court's still saying that I am advancing these positions in bad faith and so forth, and persistent or insisting that my point of view is correct, not yielding on that point of view. Well, am I required to yield on that point of view, or is it really an appellate question? Is it something for the Court of Appeal to look at and decide whether they want a precedent in the United States, in the state of California, that money in a bank account is not going to be tool of the trade? If the court's going to take the position that I'm wrong, then the court should present the authority on the order to show cause, to show me that I'm wrong. Likewise, if the court's going to take the position that I'm wrong for saying that the objections were untimely, then the court needs to say the reason. It needs to say, look at document number 118 or 94 or 61. Can't you see that $211 on the Fidelity bank account is on that objection and it's timely, and you're saying it's not timely? Take a look. The court's saying, look at your petition, document number 101. You filed it on June 12th. And he filed his objection on July 10th, document number 118. What are you talking about? That's a frivolous argument, Mr. Shalaby. It's timely. He did it within 30 days. But the court is not even responding or addressing the fact that the item is not on that objection. We don't have the $211 on it. We don't have the $3.11. And when I say items, I'm talking about the items on pages 1 and 2 of document 124, filed on July 22nd by Mr. Davis. I'm not able to understand why the court says that I am advancing an argument that has no merit and deserve to be sanctioned for it without telling me what the court's talking about. I'm at a loss for it. This is a very painful experience for me to stand here before the court today and have to face an order to show cause under these circumstances. And I'm just asking the court to appreciate the fact that when a court issues a sanction, a penalty, and especially if it goes to the trouble of publishing it as a memorandum, other attorneys see it. And some attorneys, like myself, are going to be terrified of appearing before the court and before that particular judicial officer in the future. It's going to chill a First Amendment right. I'm asking the court to consider that. As far as the amount of the sanction the court's going to impose, how much time and money was incurred by the trustee? That's a fair question. I think the court would have to agree. There was but one motion, document number 124, filed by the trustee, which was actually not a motion. It was a status conference. On that status conference, he was asking for turnover of the items on pages 1 and 2. There's but one opposition, document number 146. Probably consisted of 4, 5, 6 pages at the most. There was a hearing on September 3rd. The trustee shouldn't get compensated for that because the trustee acknowledged that he made a mistake and there was no notice for that motion, and therefore that shouldn't have happened. There was a hearing on October 1. So he had to appear at that hearing, which I think took about 20 minutes. So the amount of time that the trustee expended in dealing with these issues is the amount of time that he spent in court addressing those issues on October 1. Mind you, the majority of those issues are not even addressed on his pleadings at all. He didn't even put points and authorities on his pleadings, document 124, or even on his reply brief. So the amount of money that we're talking about should take that into consideration. What it shouldn't take into consideration now are depositions where he's asking Mr. Nakuda questions about bank accounts and assets and things that have nothing to do with the order to show cause. The majority of it had to do with confusion. What's a partnership? What's not a partnership? Give me your history about this or about that. Let's talk about Boris metrics and that sort of thing. Then he's got a bunch of filings from October 28th. They have to do with objections to a variety of creditor claims. I have nothing to do with that. He's got some yesterday. He's got some today. Again, denying creditor claims. I have nothing to do with that. So to the extent that the court is clearly persuaded that a sanction needs to be imposed, I would ask the court not to impose it with an upset heart and an upset mind or an anger, but to impose it fairly. That's all.
All right. Mr. Davis, what I'd like you to do, I note that from papers you filed dealing with this order to show cause, which was the declaration of yourself regarding the court order to show cause regarding Mr. Shalaby, there was an Exhibit N which had professional services rendered, fees and costs. What I would like you to do is file a declaration attaching your firm's records as to what had to be done, fees and costs, but limiting it to the points outlined in the court's order to show cause. I think you acknowledged in your declaration that there's a lot of work that would have been done no matter what had this case been properly handled. And there are other things that are being done that are not related to the order to show cause. The order to show cause is quite broad, but there are some things I would assume that you've had to deal with that were not specifically referenced in the order to show cause. Those should not be included, but include all those records, and if you can, what I'd like you to do is highlight that and state a number as to what you feel the trustee has had to incur as a result of these actions outlined in the order to show cause. How soon can you do that, Mr. Davis? And given the holidays, there's no rush on this.
2 weeks.
All right. What I'm going to do is afford you until today is the 20th. If you could have that on file with the court no later than December 11th. And then, Mr. Shalaby, I'll give you until January 2nd to respond, and it would have to be on a line-by-line item why that doesn't address an issue that's addressed in the court's order to show cause, and then the matter will be taken under submission. All right. Anything else? Yes.
Can the court give us an idea about the hourly rate that he's going to be entitled to?
It'll be laid out. It's laid out in his papers.
So whatever he says is hourly rate, that's what the court's going to look at.
All I can say with regards to that is Mr. Davis has routinely had to file fee application, and he's used this rate not only before this court, but before other judges as well, and it is a rate that this court has approved not only for firms and of attorneys of Mr. Davis's stature, but for other similarly situated counsel and firms. But to the extent you wish to raise an issue with that, you are free to do so.
And as far as the timing, Your Honor, this matter is very stressful, and if it goes on to January, that's just going to be more sleepless nights for me.
Well, then here's like what the deal is. I'm giving Mr. Davis until December 11th, and if you wish to respond, as soon as you respond, I'll be in a position to take it under submission. So that ball will be in your court if you wish to file it. I'm just simply saying on the outside, I'm giving you until January 2nd, 2015 to file a response to anything that Mr. Davis files in a timely manner.
And the court's ruling will be issued without a hearing?
At that point, I think the only thing I need at this juncture is that's one of the things I want to look at are what the fees and costs incurred by the trustee as a result of your actions. And so you'll have an opportunity to look at those fees that are being requested, and you can go through line by line, and you'll have to, saying why you agree or disagree as to the appropriateness of them. If the court chooses to issue a sanction.
Okay.
All right.
Just a technical question. If I yellow highlight that, and that will e-file, will it, I believe, won't it?
That or put an asterisk by something like that, so it may not get picked up on the e-filing, but if you put an asterisk by it, but something in the declaration.
I'll underline it then. That's
all right. Just I want to make sure that the courts and Mr. Shalaby can look at it. We'll go from there. And also with regards to the court's OSC, the court still reserves jurisdiction.
I didn't quite understand that. Jurisdiction to impose sanctions.
The court still is reserving its right to expand this order to show cause once the pending appeal of Farouk Nakuda versus Paul Mansdorf Bankruptcy Appellate Panel case number 14-1235 is resolved. Furthermore, there were some papers filed by Mr. Mark Romeo to the extent that he seeks any type of OSC. He can apply for it, but otherwise, if he doesn't, I'm not going to address that issue. He'd be free to deal with the issues he's raised either in the bankruptcy court, or maybe it might be more appropriate to raise with the state court. But again, I have nothing before me by Mr. Romeo that's been properly put before the court. But the court is reserving its right to expand this OSC as set forth in the OSC, which the court issued on November 4th at docket number 165. All right?
On the one issue of the appeal, the court is reserving, meaning what? I mean,
Shalaby, I'm not going to go. I'm reserving jurisdiction to expand my OSC. What you choose to do with the appeal, I leave that up to you. I'm not
Okay.
I'm not pining upon it. I'm just simply saying I won't expand this OSC until after that appeal is resolved.
okay, we've covered the court's 7 points. Can I say something about that?
What?
My understanding is that if we are not successful with the appeal, the court's going to consider awarding additional sanctions in the form of fees to Mr. Davis under the sanctions statute. But if I prevail with the appeal, I'm not going to get anything. That's a problem for me because, as the court sees from the authority that I cited on document number 176, that's exactly what the United States Supreme Court does not want this court to do. It's exactly what they say. They don't want the lower court to indicate or even threaten that it's going to sanction post-appeal.
I'm not talking about that. I'm talking about I'm not going to take any further action of expanding the OSC if I think it's warranted until that appeal's resolved. That's what I'm saying. I'm not saying don't read more into it than I think you're attempting to. All right?
Okay.
All right, thank you, gentlemen.
Thank you, Your Honor.